Tax law is a pipeline, not a single document. Congress writes the statutes, mainly in the Internal Revenue Code. Treasury and the IRS administer those statutes by issuing guidance and running enforcement, and the courts interpret the law when taxpayers and the IRS disagree. On the EA exam, they love questions that ask, who actually makes the law versus who explains and applies it? Start with Congress. Congress originates tax law, and the Internal Revenue Code is the core source you cite first. That's why, when a question asks for primary authority, your mind should jump to the code before anything else. Everything downstream, regulations, rulings, procedures, exists to explain, implement, or apply what Congress already enacted. Next is the executive branch. Treasury, through the IRS, is the collection and enforcement arm. The IRS does not pass tax statutes. It translates the code into detailed operating rules and guidance. For exam purposes, know the big buckets: Treasury regulations, revenue rulings, revenue procedures, notices, and then taxpayer-specific guidance like private letter rulings and technical advice memoranda. Then come the courts. Courts resolve disputes and interpret both the code and the regulations. They also have the power to declare a tax law unconstitutional. A big exam takeaway is the relationship between statutes and regulations. If a regulation conflicts with the code wins. But if the regulation is a reasonable interpretation of an unclear statute, courts often uphold it. Now, let's sort primary authority versus substantial authority. Primary authority includes the Internal Revenue Code, Supreme Court decisions, and tax treaties. Substantial authority can include final and temporary regulations, court cases, administrative pronouncements, and even congressional intent shown in committee reports. On the EA exam, they'll test whether you can tell the difference between real authority and helpful but not authority. Here's the trap. IRS publications and form instructions are useful, but they generally do not create substantial authority for penalty protection. They may be outdated, simplified, or incomplete. So if a question asks what supports a return position to avoid an understatement penalty, Publication 17 is usually the wrong pick. One nuance: the IRS has moved many FAQs into fact sheets, which can count as authority. The U.S. courts give weight to Treasury regulations and will generally uphold the regulations, so long as the IRS's interpretation is what? Your choices include reasonable, permitted, according to congressional intent, or allowable. Think about what standard courts use when a statute is unclear. The correct answer is reasonable. Courts generally uphold Treasury regulations if the IRS interpretation is reasonable and not contrary to the Internal Revenue Code. A tempting wrong answer is according to congressional intent, because intent matters, but the tested phrasing is the reasonableness standard, especially when the statute leaves room for interpretation. Section 330 of Title 31 of the U.S. Code authorizes what type of regulations? The options include regulating practice before Congress, FinCEN, the U.S. Tax Court, or regulating practice before the Department of the Treasury, including the IRS, and determining practitioner fitness. Think about where Circular 230 authority comes from. The correct answer is regulating the practice of representatives before the Department of the Treasury, including the IRS, and determining practitioner fitness to practice. That's 31 U.S.C. Section 330, the backbone for Circular 230, discipline, and even monetary penalties. Tax court is tempting, but Section 330 is Treasury and IRS practice, not court procedure.